a chart here with all the Muslims who are deemed as scheduled tribes, and isn't it part of the constitution as per law that the scheduled tribes property cannot be transferred without the individual's permission? So there has been another angle that has been raised by the senior advocate. Back on the telecast with me is Ashwini Dubey. Ashwini, shed more light into what are the aspects of the scheduled tribes and the laws that have been brought in to protect their properties, to protect their identity, that are going to overlap with the Waqf Amendment Act? Some back on the telecast with me. Some again, how does this scheduled tribes property and the overlapping of the Waqf Amendment Act is that going to hamper the government of India's case while fighting the case?
Well, absolutely. See, this time Chief Justice of India is asking, Chief Justice Sanjeev Khanna is asking, what about the protected monuments? And exactly this Kapil Sibal is saying, are you talking about the Jama Masjid? So CJI said, no, Jama Masjid was declared a protected monument under earlier law, and the reading is in your favor, and that if it is declared an ancient monument or under the ASI Act, then Waqf status cannot be disturbed. This is what the Chief Justice of India is saying. All ancient masjids will be protected and not hit by the act. This is what is said by the Chief Justice of India, and to which the senior advocate Kapil Sibal is saying, suppose you go to Sambhal, CJI said, let it be, we will ask the other side. So these are the exact arguments going on in the Supreme Court, and the hearing is underway. A crucial, very crucial hearing, very crucial arguments underway.
Right, absolutely. In fact, there is more of those points that have been put out by the senior counsel. He is talking about how the challenge of implementing the Waqf Amendment Act is an issue that is essential to a faith. There has been a response by the Chief Justice of India, who has spoken that inheritance is a matter of personal choice, whether it comes to Hinduism or Islam or any other religion that is practiced within the country. And there is a law that has been enacted for the Muslims. There is in fact a law that has been enacted by the Hindus to then regulate, to screen and to monitor the properties that are inherited by individuals practicing different religions. Ashwini is all right. Before I get to Ashwini Dubey, what are the CJI's comments? What are these laws that have been implemented? What are these legislations within the parliament that have been enacted, which allows for the state, which allows for the government to monitor the inheritance that is inherited by Hindus? I have with me Advocate Fuzail Khan. Fuzail Khan, again the argument put forth, the counter argument put forth by the Chief Justice of India, that when there is an enactment of a legislation in the parliament to monitor and screen properties of inheritance of Hindus, why should something not be applicable in a similar vein for Muslims?
Am I audible to you?
Yeah, I can hear you. Please go ahead.
Yes. So we are discussing about the Waqf, that is the Waqf Amendment Act, which has been passed by both the houses of the parliament and which is under challenge before the Supreme Court of India. And the reason why the Waqf Act has been challenged, because there are certain provisions in this act which actually contradict the basic essence of Waqf. So the Waqf has to be managed in a proper manner, and the management is led by the mutawalli, and the mutawalli is a Muslim who actually manages the Waqf property, and who generates wealth, and that wealth, whatever is being generated through the Waqf, it has been distributed among the needy, poor, and the desired within the community and also outside the community. Now, as far as this act has brought, it has given certain absolute powers to the district magistrate, and then there can be a challenge to it, and there are certain Waqf properties which are century old, and they may not be having certain papers with regard to the Waqf, so the district magistrate may have powers to de-notify it, which will actually defeat the purpose of the donor who had donated this property in the name of God, because there is a little bit of difference between endowment and the Waqf under the Sharia law established under the Islamic state. Or the basic purpose of the Waqf was that Waqf is created in the name of God. So there is a belief that once a property that has been created for the purpose of Waqf, then it cannot fall back to the state or to the donor or to any other person, because Waqf is in the name of Allah. So once you de-notify it, it's going to create a lot of problem, which has to be examined by the court of law as to what will be the position, first of all.
Okay. Okay. I'll have to interrupt you while we take a look back in the history and what are these rules and regulations that are followed in Islamic law. I'm going to bring back Anand on the telecast with me. Anand, give us more information about Justice Vishwanathan, who has spoken about, putting out counter arguments to the arguments that have been put forth by counsel Sybil, and more importantly, how the CJI has spoken that ancient monuments are going to be protected from the Waqf Amendment Act, which includes the monumental Jama Masjid monument. How is that going to impact the ruling that is likely to be pronounced by the Supreme Court today or later in the coming days?
Yeah, Megha, look, the way in which the CJI himself mentioned about that, how several of the Waqf properties that also include several of the high heritage properties, they will be protected by this Waqf Amendment Bill that has been passed by Parliament and also cleared by President Draupadi Murmu. And his main important because in the Waqf properties, there are several of the very high historical value monuments which are available in the country. And we have seen that how several of the Waqf properties are not properly maintained. So this is where the CJI has stressed, and he said, he had mentioned about the same, while Kapil Sibal, who is arguing on behalf of the petitioners in this case, he has mentioned that how Article 26 of the Constitution was not being followed and how several rights of the Muslims were being taken away. So clearly a lot of deliberation is going to take place and a lot of argument is going to take place in the Supreme Court as the CJI is going to listen to all the arguments, and he will be also making some remarks, and he will be taking into consideration several of the arguments that Sibal will be giving. So we are expecting that in the coming days, as there are a lot of other petitioners also which the Supreme Court will be hearing in this Waqf Amendment Bill that has been challenged in the Supreme Court, because there are several other leaders who have also approached the top court in regard to this bill. And so the Supreme Court will first of all hear one by one all the petitioners, and then only it will be coming to conclusion. Back to you, Megha.
Right, Anand, also, one more argument that has been raised by Kapil Sibal, as has been raised by other political leaders who have filed petitions about how the Central Waqf Council has all its nominees that at one point of time used to be Muslim, but under the Amendment Act, that constitution is going to change. There are going to be government officers that are going to be part of this council, and then he has juxtaposed it to the Hindu and Sikh endowments, where nominees are Hindus or Sikhs respectively for each of these endowments in each of these councils that regulate these endowments. So why is there an exception for the Muslim council that has been made for Waqf properties?
Look, this was one of the main points of deliberation when the JPC was formed over the Waqf Amendment Bill, and we have seen that how several of the parliamentarians who were part of the JPC on the Work Amendment Bill that was given the right in the budget in the last session. So clearly, there is a lot of deliberation went upon that how the work amendment, the work board, which consists of all the Muslim people and few women leaders over there from the Muslim community. So now the argument is giving that now the government has allowed for 22 members in the work board, and out of which 10 will be from the Muslim community, while 2 will be women, and while rest will be from other community. So a lot of discussion is going on the same, despite the government has given them some assurances. However, this need to be looked upon that how Kapil Sibal is going to argue on this part, and how the CJI is going to react on all the arguments that are being made by Kapil Sibal before the Supreme Court over here. Back to you, ma'am.
Okay, back to my guest. Let's hear it from you, sir, particularly about what the argument is on the constitution of the council that is going to regulate and monitor the Waqf board. The question being raised is, if the Hindu and the Sikh endowments only have Hindus and Sikhs that are regulating and being part and being the trustees of that endowment, why is such a provision not being allowed to be carried forward for the Muslim trust, for the Muslim Waqf board? Can you hear me? Advocate Fussell, the question is for you.
Yeah. So actually, I'll just say that the first and the foremost thing which every viewer has to understand is that there have been judgments of the Supreme Court where the Mutawalli has been appointed, who is a lady, and more importantly, a very famous family in this country, the Nawabs of Bhopal, the Saif Ali Khan's family. The Mutawalli is one of his sister. So there is no harm, and I think there have been judgments to this effect. But the major issue is with regard to inclusion of a person who does not practice Islam. See, you have to understand one thing, that what was the reason to bring in a person to manage the affairs of a Waqf, which is a religious body, or a property which has been created for a religious purpose. And more specifically, if I can say, that it is a kind of a method which originated under the Sharia law, which is to be managed and operated by Muslims. And then the government brings in a law, and then they say that, there will be a person who does not practice Islam. So even, there have been instances where you hear a name of a Muslim person, but he may not be practicing Islam. So one who manages the affairs of a Waqf, he should be a practicing Muslim. So this is a point which actually pinches the community, the people of the community, that how will they, because you have to have a feeling, you have to have that kind of sentiments, you have to have that kind of emotion to deal with those properties. You have to be a Muslim, so in order to manage the affairs of the Waqf. But now, since the Parliament has passed the law and it is before the Supreme Court of India, so let's see what the court takes a stand on this point of view with regard to inclusion of non-Muslim in the affairs of a Waqf. Right. But definitely, I think there's one more thing which I just want to say at the last is this, that to have that it has been rightly said before the Parliament and before the court also, because I have not heard Mr. Sibal arguing. But if he has said so, that you have institutions and endowments and SGPC which is completely filled with a person who actually practices that particular religion, so then the government should have created a kind of an endowment act, or some kind of a universal law which could have been applicable to all the religion. You should have clubbed it. The charitable institutions, the endowments managed by different communities and sects, including the Waqf. But why choose only one particular subject? This is also a point, because there cannot be a discrimination.
And right. Okay. And another point, I want to get your inference in this. When Kapil Sibal argues and says that inheritance of property in Islam takes place after the death of an individual. So why is the government of India interfering in this case even before the property is transferred to the successor, the inheritor?
Yes. So he has rightly said so. See, because instead of bringing these piecemeal kind of things, the government the government of India, when this government has a complete majority in both the houses, so they should press for the uniform civil code. Why not have it in that way? So everybody will be treated equally. Why they should be carving out for Muslims or for any other particular sect or a religion? Because this is more or less, with all caution, I can say that this is a kind of a pick and choose policy to satisfy your own set of people, to satisfy your own mandate. You run into these things, and then these things come before the court, and then court is going to examine this issue. But even the court will examine it in the light of the Sharia law, like we have seen in the case of triple talaq. The government of India brought in a law. The Supreme Court passed a judgment to this effect. The Supreme Court examined all the aspects, and then it said no, that as per the Muslim law, there is no such thing as one go triple talaq. So let the court examine this point also with regard to the Waqf, and let the court come out with its own view. But I think, in my personal opinion, that's completely my personal opinion, the government of India, after forming the committee led by Mr. Jagdambika Pal, they should have also taken into consideration by appointing at least 5 retired Supreme Court Muslim judges, or some judges of this court who retired and who are expert in the Sharia law. And there have been many non-Muslim judges who have given very fine judgments with regard to Muslim law, Sharia law. So they could have been taken into the wagon, and they could have, given out a much better, wider view.
Okay, all right, stay on with me, back on the telecast with me. Izan and Anand, what right now, a number of these contentions being put forth by Kapil Sibal, what do you think are going to be the counter arguments of the council representing the government of India?
Yeah, Megha, look, the way in which Kapil Sibal is arguing in the Supreme Court with the 3-member benches, so clearly he is highlighting all the points which several of the MPs in the JPC have mentioned before the JPC chairperson and several other members, before the act was being brought, the bill was being brought into the parliament for passage. So clearly all those points are being highlighted, as Kapil Sibal is also arguing that how the government officials will have their say over the work properties, and it was all because of that the government has just said that only 10 or 12 members will be from Muslim communities, while the 10 others will be from the government officials and other communities. So clearly on this point, Kapil Sibal is arguing now, and he is mentioning all the facts before the bench over here at the Supreme Court. And it will be very interesting to see that how the Supreme Court is going to come out on this Waqf amendment case, the bill that was passed in the parliament in the recently concluded parliament session. So clearly the Supreme Court judgment will pave a way that what it feels about the Waqf amendment bill that was passed by parliament and also agreed by President Draupadi Murmu.
Yeah. Also, there's an argument that has been put forth now by Advocate Dhawan, who's also fighting and representing the petitioners. He says the basis of the constitutional attack is that Waqf is essential and integral to Islam. Religion, particularly charity, is essential and integral part of Islam. So he's raised this one more point, which he's talked about. Charity is something that is peculiar to the religion of Islam. There has to be, as per Islamic law, some percentage of an individual's earnings that have to be most definitely donated to charities, and this forms the integral part of the Waqf Act that was being followed up until the amendment took place. How is that going to impact the ruling in the case?
All the points that are being argued in the courtroom, and this is where there are several points, as I mentioned earlier, that on which a lot of deliberation and discussion need to take place, as Kapil Sibal and several other lawyers over there, they are arguing and they are mentioning all these points inside the courtroom, and also that how the money that the work gets in the form of rent or several other income generations, and how those monies are spent and for what purposes, and what kind of charities those money are used. So clearly a lot of discussion, a lot of argument is going to take place until the time the Supreme Court is not satisfied with the argument. It is not going to let it go, and then only it will decide after completing the whole argument on this
Right.
case. Back to you, Megha.
Anand, stay on with me. Advocate Faisal Khan, shed no light into this argument, which seems to be a strong one, that charity is essential and an integral part of Islam, and therefore the Waqf Amendment Act interferes in the donation that is made by millions of Muslims across the country to the Waqf Property Act.
Ma'am, there is a slight difference, as my friend has told. See, he talked about charity. So charity is basically zakat, and zakat is 2% of your annual income, which you have to give it in the form of zakat. So this is the charity part, but there is a slight difference between zakat and okaf, that is waqf. So waqf is basically given by a kind of a richer people or rich people of our community, and that is like at one point of time when people have a lot of wealth, so they create assets such as marketplaces or some kind of like one of the like there are many industries also, so they donate one part of their industry, they create it as a waqf. So whatever wealth that comes from that particular product, that goes into the benefit of the marginalized section. So yes, charity is an integral part of Islam, because there are 5 pillars of Islam, that is Hajj, Zakat, Namaz, and the other one, charity. So, but with regard to Awqaf is not mandatory. It is not at all mandatory. But yes, those who have deep pockets, who have more than sufficient means to, outside after running their household, they have that kind of means. So they can create waqf in the name of God, and whatever benefits are drawn, that goes into the welfare of the marginalized section. Like for example, you might have seen a lot of mazars of Sufi saints. So whatever income that is generated from there, that and whatever shops you might have seen there, or whatever business activity that has been taken in and around that area, so that property is a waqf property, and whatever income is being generated through shopkeepers, through rent, is that money is used for the marginalized section. But let me just say one thing. See, I cannot absolutely say that the government of India is wrong, because of the reason that as far as the Waqf management is concerned, Waqf boards are concerned, it is in a deplorable shape in any state, in any city.
I'm going to come back to you on this. I have to put out information as it is happening in real time inside the Supreme Court. Advocate Abhishek Manu Singhvi has now spoken. He's put out the argument that there are 4 out of the 8 lakh Waqf properties, and to which the CJI has said that the Delhi High Court itself is built on Waqf land. So that's the update. Back to you, Anand, about this, about the fresh argument being put by Abhishek Manu Singhvi, talking about 4 of the 8 lakh properties, and they are all Waqf, and the CJI putting out information that even the Delhi High Court is built on Waqf property. Does this complicate matters?
Yeah, Megha, look, now Abhishek Manu Singhvi has just made his argument, and he has started putting facts before the court over here. So clearly the CJI has also, and the courtroom also accepted that how Delhi High Court property is also on the located on the Waqf property. And it is not only about Delhi High Court. There are several other prominent buildings in the national capital that is located on the Waqf land. So clearly, these were the arguments also that several of the MPs made in the parliament, and they mentioned about 123 Waqf properties that are in Delhi, and on which several important locations are present over there. So clearly, they had also argued that how when the Lutyens was formed, that how these properties were made to remain as same even when the Lutyens was created. So clearly, a lot of discussion is going to take place on all these aspects, that how these properties have remained for decades, and not decades only, for centuries. So discussions will be being held on all these, and also the arguments will be made that how such important offices or courts rooms are also present or located on work land. So clearly arguments will take place on this, and then only the court will come to any conclusion. So it will be very it will be we need to wait as how the arguments are going on in the room, and we have to wait and watch that which way the argument is going before coming to any conclusion. Back to you, Meghna.
Mendi ka ground to telecast with the Mendi. What is the latest that is happening? We see Advocate Dhawan. We also saw that Advocate Kapil Sibal was the one who commenced the arguments, and now we see that we have Senior Advocate Abhishek Manu Singhvi also putting forth his points in favor of the petitions against the Waqf Amendment Act.
Well, indeed, Megha, right now, Abhishek Manu Singhvi is putting his point up, and he said that 4 out of 8 lakhs are worked by user by one stroke of pen. And on that, CGI has said that they have been told that Delhi SC is built on Waqf land, and also they are not saying that all worked by user is wrong, but there is genuine concern over that. And on that also, Megha, Abhishek Manu Singhvi has said that in 118 of Ayodhya judgment, it was said that it is a very old concept, and they have removed the bases, and also seeing practically 4 out of 8 lakh are the Waqf properties. Not only this, also it has been said by Abhishek Manu Singhvi, and before that, when Kapil Sibal was speaking, he also said that let's come to Article 14, and the discussions over Article 14 also happen in the court, and it has been said by Kapil Sibal that that is too being violated, and he also argued that the entire process is essentially a takeover through nominations. And also, referring to the 1995 Act, he also said that under Section 9, all Muslims are covered, and also Section 14 provides for a board comprising only Muslims. And on that also, Kapil Sibal referred to the Ram Janmabhoomi judgment as of now as well. Yes, Megha.
Okay, talking about Abhishek Manu Singhvi's argument, he speaks about 4 out of the 8 lakh properties are Waqf by user, and the CJI has said the Delhi High Court itself is built on Waqf land. So Waqf by a person inheriting the property and then donating it, versus Waqf by user, that even if the property has not been donated and if it is used for charitable and religious purposes for a long time, it also comes under the ambit of the Waqf property, Waqf Act. And why is there a contention being raised by the petitioners over this taking over of the property by Waqf by user is the term that has been used over here. Advocate Faisal Khan, can you give us more information about this? Waqf by donation versus Waqf by user. What is the difference between both the properties, and why has this argument been raised in court?
Is something which is being named in the name of God, and the benefit goes to the people at large, the needy people. Now there is another term which is Waqf by user, which is known as Waqful Aulad. So earlier, at one point of time, there were judgments of the Privy Council which says that Waful Aulad cannot be entertained because Waf has been named in the name of God, and the benefit will go to the common people or to the needy people. But then during that period, there have been judgments which say no, a Muslim man or a Muslim person can create a Waful Aulad. So that is for your own benefit. Like suppose that I create a Waf for the benefit of my family, and that will continue to go on, and no third person is going to enjoy that right. But definitely, my children, grandchildren, or the coming generation cannot sell it off because it's a waf, but the fruits will be enjoyed by the family itself. And when there is waf for the common, so whatever fruits are there, that is to be enjoyed by all. So
Okay. Okay.
that is the minor difference.
Okay, all right. Sambhav Sharma back on the telecast with me. Sambhav, what are the latest updates right now from inside the court?
Well, after senior advocate Kapil Sibal, it's senior advocate Abhishek Manu Singhvi who is putting out his argument before the Chief Justice of India, Sanjeev Khanna, and he is saying that 4 out of 8 lakhs are waf by user by one stroke of pen. This is what is said by Abhishek Manu Singhvi to this. The Chief Justice of India argued that sorry, we don't want to interrupt. We are told that the Delhi High Court is built on waf land, and we are not saying all waf by user is wrong, but there is genuine concern. This is what is said by the Chief Justice of India. This is very important to note here. Now to this senior advocate Abhishek Manu Singhvi is saying in 118 of Ayodhya judgment, he is quoting now Ayodhya judgment here, and he is saying, Singhvi is saying that this particular judgment, Ayodhya judgment, says that it is very old concept. Have you removed the basis? He is also talking about the nitty-gritties of the judgment, Ayodhya judgment. He is quoting Ayodhya judgment here. So these are the arguments being underway in court number 1, and where over 70 petitions are being challenged,
Right.
being heard in the Supreme Court.
Right, absolutely. Coming back to you, Anand, in wake of all the hearings that are taking place in the hearing that is taking place inside the Supreme Court, what's the scene outside? Are there more political leaders from the opposition or from the government side who have come and reacted to the Waqf Amendment law being challenged in court?
Yeah, Megha, look, if we talk about the political leaders and their supporters being available outside the Supreme Court, so there is a clear silence over here at the Supreme Court lawns, and we can hardly find any of the petitioners or their supporters over here. So clearly, if their lawyers are making arguments inside the courtroom, then their petitioner must be with them inside the courtroom only. So once they come out after the court hearing, then only we can speak to him and we can get their reaction that what all went inside the courtroom. Back to you, Megha.
Okay, there has been an important, significant point that has been made by Advocate Sanjay Hegde. He's spoken to the 3-judge bench. He's spoken about how Amritsar was at one point of time in non-Sikh control several times in history, and it required an Akali Dal movement to change that. And now this is the reference that he has made, making a comparison to the Waqf Amendment Act, Advocate Faisal, and how there has been the inclusion of non-Muslim members to the board of trustees who are then going to manage this endowment. So does this argument hold water in court?
Remind you one thing, as Mr. Anand has said before your viewers, with regard to the Ayodhya judgment, which has been quoted by senior advocate Mr. Abhishek Manu Singhvi. So let me remind you of one thing, that there were, I think, a few review petitions filed against the Ayodhya judgment, and the bench was shared by the present CJI, Mr. Sanjeev Khanna. So therefore, as of now, the Ayodhya judgment holds a lot of value because that review petitions were dismissed, and what has been quoted by Mr. Abhishek Manu Singhvi still holds the ground. So this is a very important aspect that has to be kept in mind. Now, with regard to inclusions of non-Muslims in the management of the affair, so there are two two views. The first thing is this, that the court may see that, whether interference, what kind of interference does it mean if you include a non-Muslim to the management of the Waqf. So they have to examine the entire Sharia law, and they have to go into, because like for an example, if I just give you one short example of the Constitution of India, there is a one very famous case of a Jabalpur case, ADM Jabalpur case. So there are two words in the Constitution of India. One says the citizen of India and the other one says a person. A person may be a citizen of India, a person may not be a citizen of India, but a person means a person of any nationality or a no man's land, but he has been given certain basic rights, certain fundamental rights within the Constitution of India. So on that particular parameter, the court has to examine that whether there is a strict interpretation or a liberal interpretation of the Sharia law. So this is a very, very tough task, but as far as I am concerned, it is not about a strict interpretation or the liberal interpretation. The court has to lift the wheel and to understand the basic purpose of the parliament, because the parliament has passed this law with a majority, and a government in majority which has certain other aspects in mind. So the court has to examine three things. First is that whether under the Sharia law there is a strict interpretation and only a Muslim can manage the affairs of Waqf, or whether there is a liberal interpretation, or whether there have been instances around the world which they can prove, which the respondents can prove, yes, there have been Waqfs which have been managed by non-Muslims, those who are not non-believers.
Okay.
But as far as I think, because there has to be one thing which has to be understood by your viewers, is this, that under the Sharia law, a Muslim man can marry a Jew or a Christian without converting. But if he marries, except for these three, that is a Muslim man marrying a Muslim woman, or a Jew or a Christian, then in that situation conversion has to take place, otherwise that marriage will be void.
Okay, stay on with me. Back on the telecast is Sambhav. Fresh developments. Solicitor General Tushar Mehta has now put forth his arguments. He said that there has been a constitution of the Joint Parliamentary Committee. This Joint Parliamentary Committee held as many as 38 sittings. The committee visited major cities, it held several consultations, and it looked at 29 lakh suggestions and recommendations that were put forth in front of it. So where are these arguments leading up to?
Yes. Absolutely, this was very much expected, and now the the law officer of the government of India, Solicitor General himself, Solicitor General Tushar Mehta himself, is defending the Waqf Amendment Act, and this was very much expected as we were discussing. And now the Solicitor General Tushar Mehta is saying you are dealing with a legislation. There was a joint parliamentary committee formed, and JPC, the Joint Parliamentary Committee, formed, and 38 sittings happened of this joint parliamentary committee. It submitted its report in the parliament, and it visited many areas. So he is providing all the details of the joint parliamentary committee, which was headed by Jagdambika Pal, and post which the particular bill was tabled in the parliament, discussed in both houses of parliament, got note of the President of India, and became the law of the land. So this is how the procedure happened, and this is exactly what the Solicitor General Tushar Mehta, defending the Waqf Amendment Act, is saying before putting his argument before the Chief Justice of India. And he is saying there was this joint parliamentary committee, 38 sittings were there. Joint parliamentary committee visited many areas. It examined over 98 lakh memorandums, and then it goes to both houses of parliament and the law is passed. So there was this big tedious process.
Some also shed more light into the explanation that has been provided by Solicitor General Mehta, explaining what Waqf by user is. He said Waqf by user is an argument most contentious. Why does the clause of Waqf by user that is included in the Amendment Act has become so controversial and has been raised by the petitioners?
Well, as absolutely, solicitor is putting his arguments in support of the Waqf Amendment Act and also defending the Act, different provisions of the Act, and also the kind of non-Muslim members included in the Waqf board and Waqf councils, because this is the main bone of contention, because of which many Muslim bodies are saying that it is impacting the basic structure of the constitution, the article 26, 29, which are the articles for the minorities, and that is why they have come here in the Supreme Court to challenge this particular act. So here Solicitor General Tushar Mehta for the Government of India is defending the Waqf Amendment Act and also different provisions, because earlier to Solicitor General, two big senior advocates like Kapil Sibal and Abhishek Manu Singhvi put forth his arguments, and also when it comes to Abhishek Manu Singhvi, he asked for the stay of the particular act. He asked for the stay. He said, I pray for the stay of the particular act. And CJI also hinted, if we talk about what CJI said in this particular matter, Chief Justice of India also hinted that this matter could go to one of the high courts of the country. He said, and I quote, we have we can even direct one high court to hear this. So this is what the Supreme Court has hinted. This matter could go to one of the high courts.
Why are the representatives of the petitioners right now against the suggestion being made by the Supreme Court judge to hand over the case to be heard in the High Court?
Well, see, the top court of the country, it has jurisdiction over the other states as well, but the when it comes to the high courts, it has limited jurisdiction. When it comes to Article 226 of the Indian Constitution, it could be one of the reasons. However, having said that, it is not clear that the matter will go to the high court, but in one way the Supreme Court has hinted during the hearing when senior advocate Abhishek Manu Singhvi was putting forth his argument before the Supreme Court and asking to stay this particular Waqf Amendment Act. And after these, after the arguments of Kapil Sibal, senior advocate, and Abhishek Manu Singhvi, other lawyers like senior advocate C.U. Singh also argued. He also talked about Article 26, which is the article, particular article for the minorities in the Constitution of India, and also one Kashmiri Pandit lawyer intervened, and P.A. Wilson, he is also a senior advocate. He said that through this entire enactment, they want a provision period of 5 years for a person to prove that he is a Muslim. So the identity of a person is being questioned by this particular act, is said by different lawyers who have challenged the petition in the Supreme Court, who are arguing on behalf of different petitioners who challenge this particular act in the Supreme Court. And now the top law officer.
Stay on with me, because here a question, an important one, has been raised by Chief Justice of India. He has posed this question to the Solicitor General, Advocate Faisal. What the CJI says is, when it comes to Hindu endowments, they are all generally managed by Hindus, to which Solicitor General Mehta has said that these properties, even if they are handled by Hindus, are governed by statutory. So why is the Muslim community and these petitioners particularly, who are fighting against this act, are so against the Government of India, the law, the statutory overseeing the entire process of Waqf? Advocate Faisal, can you hear me?
Yes, I can.
Yeah, so the question about if Hindu and Sikh endowments are being overseen and monitored by statutory, why can't something similar be applied for Waqf?
No, we do have a law, and it's a post independent law which had an amendment in 1995. The Waqf the Waqf in India has been managed through the statutory law. So there's no point in saying this. But yes, the amendments which the government has brought, that has to be examined by the court, because it directly hits the Sharia law, and it directly, actually, the point is this, that there is a lot of difference between dealing with the Muslim community and dealing with the endowments of the other religious communities. So that has also to be examined by the Honorable Supreme Court of India. So you cannot say why to the Muslims and why not to the others, or why not to the Muslim and to the others, because this aspect is basically a constitutional aspect which gives the right to the court to decide with regard to the fundamental rights of managing the affairs of a religious institutions, which includes the Waqf. So the court has to examine this aspect.
Okay. I also have with me Kailash Vasudev, senior advocate of the Supreme Court. Kailash Vasudev, again, a clarification required over Waqf by user versus Waqf by declaration. How do these two individual, arguments hold water in court, and is this going to impact the Supreme Court's decision over the Waqf Amendment Act's validity?
Two distinct areas. One is the private Waqf, one is the public Waqf. Now, controlling of Waqf has been a part of the Waqf Act, which has been in operation for the past God knows how many years. Today you have an amendment. The community says this amendment is affecting their rights. The matter is under challenge. Let the court decide, because you have got to have control over properties. Every community's properties, whether it's the Gurdwara Act, whether it's the Sikh, the Indian Endowments Act, whether it is the Christian Properties Act, they're all under control. The system of management. If you have a system of management, let's see how good or how bad it is, but management is necessary today. You cannot abuse properties even if given to you by way of a gift. A gift may be for the purposes of achieving the purpose of that particular Waqf, but on the other side, you cannot use the properties for uses other than that. To avoid that abuse, this amendment is being brought in.
Okay. Sanjay Rana, what's your opinion when there are arguments put forth in court, whether it is about Waqf by user versus Waqf by declaration, whether it is public property or private property, talking about how the Waqf Amendment Act is in violation of Section Article 26. Does this argument hold ground?
Megha, good afternoon. I understand that the case is under review at this point of time, and if you're talking about the Article 26, I don't think it's violating anything. That amendment that is violating anything related to Article 26. Article 26 is absolutely giving a right to each and every person, those who are living in this country, freedom, giving a freedom to follow their rules, religion, process and religion thing. But when you're discussing about the violation of Article 26, then we need to look at the Article 14 as well as Article 15 as well as Article 21. So a lot of ambiguities are there. We should not mix amendment bill with the Article 26. Absolutely nowhere. It's two different things altogether. What I fail to understand, does this law is preventing anyone to go to mosque? No. Does this law is preventing anyone to follow the religious thing? No. Does this law is doing anything else which is restricting to follow your religion? No ways. This is a statutory body, is absolutely governing body, and how these things need to be governed. That information is there, and there should be transparency. Obviously, Muslim can do their work as per their wish. They can donate anything, or anyone can donate anything on the name of Allah or on the name of God. No one is stopping it. But if anything is misuse is happening, then obviously government or somebody has to should be there to regulate it, and this is a regulatory body. So I fail to understand why people keep on talking about Article 26. Not at all violating Article 26. If it is, as per them, if it is, then what happened to Article 14 and what happened to Article 15 and what is going to happen to Article 21? Because if you look at 2013 amendment, obviously it's not giving you a right to go to court, which we have in the Constitution of India as a citizen of India. You need to understand, the legal part is totally different, and what part we are going to take it. I don't have the right to make a statement at this point of time, because court is reviewing this complete thing, and hopefully we'll get the decisions.
Right, Advocate Kailash Vasudeva, another argument being put forth by Senior Advocate Kapil Sibal, talking about the government property which has been identified or declared as Waqf will not be deemed as Waqf after the commencement of the Act. Is that true?
Look, if the Waqf provides for taking over a property, it does. There are a lot of properties. For example, you see the old heritage properties, the Taj Mahal and the Red Forts and so on and so forth. Now, these are ancient properties which come under the Archaeological Acts. How can you make a Waqf claim out of it? These are national heritages. You have got to draw a distinction between what is heritage property belonging to the nation and those properties which have come within the purview of the Waqf. Today, everything you are seeking to bring within the provisions of the Waqf. How can you do it? I mean, these are matters which need consideration by the court. You can't make random statements. Today, I turn around and say that any building standing in a particular place is a Waqf. How do you do it? What is the basis for it? You've got to have a historical purpose. You've got to have the names of the persons who have donated the properties. There are judgments of the Supreme Court and the Privy Council starting from 1890s on what a Waqf is. There's a certain system you have to follow. Because the government is making a law to standardize this practice.
But then, was there a question raised by Waqf board on who the owner of the property is and whether it needs to be brought back into Waqf board, Waqf trust before the Amendment Act was implemented? Why is there questions raised about this? Over the past several decades, questions have not been raised, contentions have not been made over the property where ancient monuments, the likes of Jama Masjid and the High Court that has been built on Waqf land, there have been no questions raised about the ownership of property.
Today questions are bound to be raised because property is becoming a matter in short supply. Everybody wants a ping in the properties. And the Waqf Act has come in because of the abuse of the authority of the people who are the trustees. They have been abusing this trust. That is what the bill says. To avoid misuse of the power of the Waqf board, that this is being done. You've got to preserve those properties. You can't go around selling them. You can't go around transferring rights. Those are sacred, sacrosanct positions which are donations in the name of the gods. But we are dealing with them in a manner that they are properties meant for the benefit of the members of the Waqf boards. That is what is the malice which they are trying to control.
Okay, and talking about why has the state appointed its officers to manage the Waqf trust? Why can't members of the Waqf trust who are appointed or elected by the trust be held responsible and trusted with the operations of Waqf?
If you see the Endowments Act which govern our Hindu temple, take for example Vaishno Devi. Most of the officers there are government officers. You take the Endowments Act which govern temples like Tirupati and so on and so forth. There again there are government officers. You look at the Sikh Act, the Gurdwara Act. There also there are government officers. The government has to be there to ensure that there is no abuse by the officers concerned. Eventually, lands which come by way of trusts have to be kept in trust. To get that trust done, you've got to have independent people because a board of trustees can always mismanage it. Under Section 92, the trusts are created. Trusts become a very big problem. All trust properties invariably go into litigation. Why should you permit that to happen?
Okay.
It is to avoid that you have government officers. We've got to rely on somebody independent.
And then also the question about why are there non-Muslims who are going to be part of the Waqf trust when something similar is not being followed in Hindu or Sikh endowments, where all members of the trust are Hindus or are Sikhs?
Matter which the court will be looking into now. You see, because the property is concerned in these cases are of a very wide and a different variety. So it is something which the court will take a call on. I don't want to comment because the matter is sub judice. There is much to be said.
Okay.
Being sub judice, that we keep our powder dry. Let the court decide what they have to say.
Okay, all right. Stay on with me. I am joined by Sambhav, who is tracking all the developments happening inside the court. Sambhav, what's the latest?
Now, well, let's talk about the latest, wherein the Solicitor General Tushar Mehta is making the arguments, and so SG is saying that before the Joint Parliamentary Committee, there was this collector who will be made the judge in his own case, and that is why the recommendation was made that it should be the higher officer than that. This is what the SG is saying, to which CJI questioned Solicitor General and said, is that fair? The moment collector starts deciding it, it stops being Waqf. Is it fair? This is what the CJI has said when Solicitor General talked about role of district collector magistrate in the Waqf board. To which the Solicitor General is saying that I mean, this is how the Joint Parliamentary Committee has come up with the new provision, and CJI is saying, where will the rent be paid? So these are the technicalities, nuances of the new this particular law. CJI is questioning on every front, almost every front, when it comes to this new law. To the top law officer of the country, Solicitor General Tushar Mehta, answering the queries, the questions raised by the Chief Justice of India. CJI is saying, where will this rent be paid, and why have you why this provision is there at the first place in the law?
Right. Okay, all right. So those proceedings will continue. I'll keep coming back to you, Samba, for more updates. Right now, joining me on the telecast is Mr. Jagdambika Pal. He is the Waqf Joint Parliamentary Committee chairperson as well as the BJP member of Parliament. Thank you very much for joining us. सबसे पहले आपसे ये सवाल, मुस्लिम पर्सनल लॉ बोर्ड प्रोटेस्ट कर रहा है पूरे देश भर में वक्फ अमेंडमेंट एक्ट के खिलाफ, आप इसके बारे में क्या कहना चाहेंगे?
मैं कह रहा हूं कि अगर एक तरफ सुप्रीम कोर्ट में सुनवाई हो रही है, तो अगर इनको देश के सर्वोच्च न्यायालय पे भरोसा है, तो उस सर्वोच्च न्यायालय का एक तरफ भरोसा है, दूसरी तरफ मुर्शिदाबाद जल रहा है और ममता बनर्जी कह रहे हैं कि हम इस कानून को लागू नहीं होने देंगे। वो पिता पुत्र खींच के घर से मार दिए गए, उनके घर पे जाने के बजाय ममता बनर्जी, या जो बड़ी संख्या में हिंदू पलायन कर गए मुर्शिदाबाद से मालदा, उनको वापस लाने के बजाय वो मौलानाओं से, इमामों से मिल रही। तो इससे साफ है कि तुष्टीकरण कर रही हैं, अगले साल के चुनाव में मुसलमान को वोट बैंक समझ रही हैं। और उस दंगाओं में ये प्रोटेस्ट नहीं है कि आप कह रहे हैं प्रोटेस्ट हो रहा देश में, ये एक दंगे हो रहे हैं कि लोग घरों को छोड़ने मजबूर हो रहे हैं। ये हिंसा है, हत्या है। और उसके बाद उसमें शामिल कौन लोग हैं? बांग्लादेशी हैं, रोहिंग्या हैं, जिनको डिपोर्ट करना चाहिए वेस्ट बंगाल सरकार को बांग्लादेश में। आज उनको राशन कार्ड दे रहे हैं, वोटर बना रहे हैं। तो अब अगर घुसपैठियों को वोटर बनाया जा रहा है, तो इससे साफ है कि आज केवल वोट बैंक की राजनीति हो रही है।
बंगाल की चीफ मिनिस्टर ममता बनर्जी का ये कहना है कि वक्फ अमेंडमेंट एक्ट जो कि पार्लियामेंट में पास हुआ था, ये हड़बड़ी में पास हुआ है, जल्दबाजी में पास हुआ है। और इस सिचुएशन में आप ममता बनर्जी के रिस्पॉन्स को कैसे क्या समझेंगे, कैसे इस पे रिस्पॉन्ड करेंगे?
तो कल्याण बनर्जी से पूछ लेना चाहिए कि ये जल्दबाजी में पास किया गया है कि 6 महीने लगातार बैठकें हो रही थी। उनके मेंबर थे उनकी पार्टी के, जो चर्चा वहाँ भी बोतल फेंक रहे थे। जब हम डेमोक्रेटिक ढंग से स्टेक होल्डर से मिलते थे और हम प्रतिनिधि मंडलों से बातचीत करते थे, उस समय भी हिंसा किसके द्वारा हुई? तो जब हमें तो अब लग रहा है कि जब कानून में हम जेपीसी में चर्चा कर रहे थे, उसी समय से टीएमसी की मंशा थी कि हम इस सीमा तक जाएंगे। और उन्हीं के मेंबर ने पूरे देश ने देखा कि मेरे ऊपर फेंक करके बोतल मारा और बोतल टूटी, उनके हाथ में भी लगी। तो इससे साफ है कि ये हिंसा आज जो हो रही बंगाल में, उसकी शुरुआत तो कल्याण बनर्जी ने हमारी जेपीसी में कर दी थी।
जी, और ये मुर्शिदाबाद वायलेंस की अगर बात करें, ये शुरू हुए थे जब प्रोटेस्ट के लिए लोग सड़कों पर पहुंच गए थे, वक्फ अमेंडमेंट के एक्ट के अगेंस्ट ये प्रोटेस्ट चल रहे थे। पर जो इनिशियल प्रोब हुई है वो प्राइमा फेसी ये बताती है कि इसमें बांग्लादेशी और रोहिंग्या का हाथ था। क्या आपको लगता है कि ये एक डेलिब्रेट अटेम्प्ट था पोलराइजेशन, वक्फ अमेंडमेंट एक्ट को मुद्दा बना के एक पोलराइजेशन, हिंदू मुस्लिम पोलराइजेशन का एक अटेम्प्ट था?
तो ये बात मैंने कह दिया कि राज्य सरकार वहाँ विफल हो गई है। आज तो स्थितियाँ, जब लोग पलायन कर रहे हैं तो वहाँ राष्ट्रपति शासन लगना चाहिए। आज वहाँ उस राज्य की स्थिति यह नहीं है। मुर्शिदाबाद जल रहा है, आज मालदा में, आज 24 परगना में भी बसें फूकी जा रही और राज्य सरकार कुछ नहीं कर रही। तो इसमें कहीं न कहीं वो उपद्रवी दंगाई बांग्लादेशी भी हैं, रोहिंग्या भी है और वहाँ के भी दंगाई हैं, और राज्य सरकार इसके बावजूद भी कोई कदम।
सीधा आरोप है कि ये हिंसा जानबूझकर हिंसा,
ये जो वक्फ अमेंडमेंट,
ये हिंसा स्टेट स्पॉन्सर्ड है, राज्य सरकार इसको संरक्षण दे रही है।
जी, ये जो वक्फ अमेंडमेंट एक्ट है, जैसा कि आपने कहा कि यहाँ पे पोलराइजेशन दिखाई दे रही है वेस्ट बंगाल के अंदर या बाकी सब जगहों में, देश भर में जहाँ ये प्रोटेस्ट हो रहे हैं, पर ये प्रोटेस्ट भारत तक ही नहीं सीमित है, ये प्रोटेस्ट पाकिस्तान में, बांग्लादेश में भी दिखाई दिए हैं। ये स्पिल होकर हमारे नेबरिंग देशों में, हमारे पड़ोसी देशों में कैसे पहुंच गए? आपको क्या लगता है, इसका क्या रीजन है?
उसको हमारे आंतरिक मामलों में हस्तक्षेप करना चाहिए। कानून हमारा है, हम अपने देश की वक्फ के कानून से फ़ायदा कैसे मिले गरीबों को, ये हमारा है। इससे साफ है कि मतलब आज जो पाकिस्तान की भाषा है वही भाषा ममता की हो रही, वही भाषा कांग्रेस की हो रही है।
हमारे साथ जुड़ने के लिए बहुत बहुत शुक्रिया। थैंक यू जगदम्बिका पाल फॉर स्पीकिंग टू NewsX. Meanwhile, there is a press briefing that is at this point of time being held by Sudhanshu Trivedi of the BJP. Let's listen in to what he's saying.
दूसरी दृष्टि से देखें तो एक विचित्र केस है जिसमें खरीदने वाले और बेचने वाले दोनों एक ही थे। तीसरी दृष्टि से देखें तो बहुत विचित्र बात है कि यह दावा किया जाता है कि यह स्वतंत्रता संग्राम सेनानियों के कंट्रीब्यूशन से और उनकी स्मृति में प्रारंभ किया गया देश के प्रथम प्रधानमंत्री पंडित जवाहरलाल नेहरू जी के द्वारा, और कांग्रेस के दौरे हुकूमत में बंद हो गया। 2008 में बंद हुआ। 60 साल में उससे पहले 50 साल कांग्रेस की सरकार रही थी। तो सवाल उठता है कि क्या कांग्रेस अपने 50 साल के शासनकाल में अपनी विरासत को बचा नहीं पाई? या वो जनता में इतनी अनपॉपुलर हो गई थी वो विरासत कि कोई उसका खरीदार नहीं था? बाकी तो छोड़िए, क्या कांग्रेस कार्यकर्ता भी अपना अखबार खरीदने को तैयार नहीं थे? जबकि राजीव गांधी फाउंडेशन को उसी दौरे हुकूमत में खूब पैसा मिल रहा था। यह अपने आप में कांग्रेस पार्टी की नीयत पर सवाल पैदा करता है। और 3 अखबार थे, नेशनल हेराल्ड इंग्लिश में, नवजीवन हिंदी में, कौमी आवाज उर्दू में। सरकारी सपोर्ट तो छोड़िए, प्राइवेट सपोर्ट तो छोड़िए, यदि 10% कांग्रेस कार्यकर्ता भी इन अखबारों को खरीदने के लिए तैयार होते तो शायद उनके बंद होने की नौबत नहीं आती, या कांग्रेस पार्टी अपने फंड में से खरीदकर कम से कम अपने जिला और मंडल स्तर पे ही डिस्ट्रीब्यूट कर देती। और मजे की बात यह है कि कौमी आवाज भी नहीं बिका, उर्दू का अखबार, यानी कौम ने भी आवाज नहीं सुनी। यह अपने आप में शक पैदा करता। परंतु मैं यह कहना चाहता हूं कि कांग्रेस की, ये मैंने प्रश्न इसलिए उठाए कि ये कांग्रेस की नीयत पर संदेह पैदा करते हैं। इसका मतलब कांग्रेस पार्टी और कांग्रेस को संचालन करने वाले नेता ये चाहते ही नहीं थे कि यह अखबार चले, और इसीलिए उन्होंने जिस कंपनी में खरीदा उसमें उन्होंने पदेन नहीं बनाया। जैसे हमारे यहां कई संस्थाएं हैं जहां भारतीय जनता पार्टी का राष्ट्रीय अध्यक्ष पदेन उस संस्था का अध्यक्ष होता है, इन्होंने व्यक्ति के अनुसार बनाया। यानी अगर दूसरे ढंग से कहें, अभी वक्फ का बिल पास हुआ है और उसको लेकर भी चर्चा चल रही है, जिस पर वक्फ वाल औलाद का विषय आया था। इन्होंने तो लगता है कि जो हमारे स्वतंत्रता संग्राम सेनानी थे उनकी प्रॉपर्टीज को भी प्रॉपर्टी अल औलाद कर दिया, यानी अपनी औलाद के नाम पर कर लिया उस प्रॉपर्टी को। परंतु मैं ये बताना चाहता हूं कि कांग्रेस की इस नियत पे संदेह सिर्फ हमको नहीं है, कांग्रेस के बहुत वरिष्ठ नेताओं को बहुत पहले से था। और आज मैं आपको कोट करना चाहता हूं, सरदार वल्लभ भाई पटेल ने नेशनल हेराल्ड के केस को लेकर 3 मई 1950 को जवाहरलाल नेहरू जी को लेटर लिखा है, जो करेस्पॉन्डेंसेस ऑफ सरदार पटेल में स्पष्ट रूप से इसका उल्लेख है। मैं उसके बहुत डिटेल में नहीं जाना चाहता, परंतु मैं उसके सिर्फ 2 लाइनें बताना चाहता हूं जो उन्होंने लिखा। इट इज ऑल्सो बाउंड टू सब्जेक्ट अवरसेल्फ टू द क्रिटिसिज्म फॉर ए मैनर इन विच द नेशनल हेराल्ड इज सिक्योरिंग असिस्टेंस फ्रॉम द पर्सन्स हु आर एसोसिएटेड विद द एक्टिविटीज ऑफ द गवर्नमेंट। आई नीड हार्डली एड टू व्हाट आई हैव ऑलरेडी टोल्ड यू अबाउट दिस सब्जेक्ट। उन्होंने कहा कि मुझे इस विषय को लेकर आपत्ति है कि यदि ये हमारा स्वतंत्रता संग्राम सेनानियों का कार्य था तो सरकार से जुड़े हुए लोग जिस प्रकार से इसमें इन्वॉल्व हो रहे हैं वह चीज आपत्तिजनक है। अब आप आइए साहब, और मजेदार बात क्या होती है कि उसके बाद जवाहरलाल नेहरू जी लिखते हैं कि इसमें कोई खास बात नहीं है। उनके पत्र का लास्ट बट 1 पैराग्राफ है, ये वो जवाब देते हैं सरदार पटेल को 5 मई को ही, 5 मई 1950 सरदार पटेल लिखते हैं नेशनल हेराल्ड के बारे में नेहरू जी को, और सेम डे नेहरू जी का जवाब जाता है और वो कहते हैं वी ऑल आर समटाइम्स रिसीव कॉन्ट्रीब्यूशंस फॉर द चैरिटेबल फंड्स और लाइक पर्पसेज, शुड दे ऑल बी रिफ्यूज्ड और शुड दे बी एक्सेप्टेबल इन द सर्टेन सर्कमस्टांसेस। कोई बात नहीं, बहुत सारे लोग कंट्रीब्यूट करते रहते हैं, सरकार से भी गैर सरकार से भी, तो हमें लेना चाहिए, उसमें कोई बुराई मुझे नजर नहीं आती है। अब देखिए सरदार पटेल 6 मई को यानी नेक्स्ट डे फिर नेहरू जी को लिखते हैं और वो इसके ऊपर बहुत विस्तार से कहते हैं कि कुछ प्राइवेट कंपनीज, कुछ शेयर होल्डर्स, कुछ लोग किस प्रकार से लिख रहे हैं। अब उनके सिर्फ मैं 2 वाक्य पढ़ता हूं। एक वो लिखते हैं एज आई रोट टू यू, ये सरदार पटेल लिख रहे हैं नेहरू को 6 मई 1950। As I wrote to you, I left out an account contribution which did not come from those who were concerned with the operations of the department. Otherwise, my information is that the number of contributions actually received was sufficiently large and covered others as well. अब आगे सरदार पटेल जो लाइन लिख रहे हैं वो बहुत गंभीर है। The transactions which I referred to you are of a different nature. There is no question of charity about it. जो आप कह रहे हैं कि ये तो भावना हत हो गई कांग्रेस पार्टी की, इसमें तो वो साफ साफ कह रहे हैं कि ये चैरिटी का विषय नहीं बनता है। अब सुनिए, उसके बाद दिव्य बुद्धि पंडित जवाहरलाल नेहरू जी की। अब देखिए इससे बहुत साफ हो जाता है कि जो आज कह रहे हैं कि स्वतंत्रता संग्राम सेनानियों का भावनात्मक लगाव था, 6 मई 1950 को यानी नेक्स्ट डे सरदार पटेल को लेटर लिखते हैं जवाहरलाल नेहरू। लास्ट लाइन क्या है उस पर गौर फरमाइएगा। एज ए मैटर ऑफ फैक्ट द हेराल्ड इज ए फेयरली गुड बिजनेस प्रपोजिशन एंड इट्स प्रेफरेंस शेयर्स एंड डिबेंचर्स आर नॉट अ बैड इन्वेस्टमेंट। आई रिपीट, as a matter of fact the herald is a fairly good business proposition and its preference shares and debentures are not a bad investment। और जो मैं आपको बता रहा हूं यह मीडिया में पूर्व में प्रकाशित हो चुका है। कई प्रतिष्ठित समाचार पत्र इसको 2 साल 3 साल पहले अपने आर्टिकल्स और जो उन्होंने रिसर्च आर्टिकल्स लिखे हैं उनमें प्रकाशित भी कर चुके हैं। अब आप सोचिए यह नेहरू जी के जमाने से ही था कि जो निवेश हो रहा है नेशनल हेराल्ड में वो बहुत मुनाफे का हो सकता है, ये गुड बिजनेस इन्वेस्टमेंट है और इसलिए इसके शेयर या डिबेंचर किसी भी प्रकार से कोई घाटे का सौदा नहीं माने जा सकते। इसका मतलब प्रॉपर्टी, घाटा, मुनाफा, बिजनेस प्रपोजिशन, यह विचार शुरू से था। आज कांग्रेस से यह नैतिक सवाल है कि अचानक आप इसके ऊपर अब वो भावनात्मक और जैसे कि स्वतंत्रता संग्राम के लिए दिए गए दान या चैरिटी का विषय कैसे करें, जबकि सरदार पटेल कह चुके हैं इसमें चैरिटी ऐसी कोई नहीं। और लास्ट में 10 मई 1950 यानी 4 दिन के बाद सरदार पटेल लिखते हैं इन व्यू ऑफ द पोजीशन विच हैव टेकन आई फील इट इज यूजलेस टू परस्यू द मैटर। यानी वे एक प्रकार से हताश होकर कहते हैं कि मुझे लगता है कि अब मुझे इसके लिए परस्यू करने की आवश्यकता नहीं है. आई हैव ऑलरेडी टोल्ड यू हाउ आई व्यू दीज एक्टिविटीज एंड दैट इज डाउटफुल. इफ इन एनी अदर प्रोविंस, if I had anything to do with this matter, this position would have been tolerated by me. अब वो कह रहे हैं कि अब मैं पूरी तरीके से निराश हो गया हूं, तो मैं इस पे पुनः नहीं आना चाहता. अब आप बताइए, मैं कांग्रेस पार्टी से पूछना चाहता हूं, कौन सा त्याग, कौन सा समर्पण, कौन सा योगदान स्वतंत्रता संग्राम सेनानियों का, या ये शुद्ध बिजनेस ट्रांजैक्शन का मामला है, तो वो कैसे कह सकते हैं कि ये ईडी के परव्यू के बाहर है अथवा यह किसी प्रकार की राजनीतिक दुर्भावना से प्रेरित है. जबकि यह विषय 2012 में प्रारंभ हुआ. अक्टूबर 2013 में यूपीए सरकार के शासनकाल में दिल्ली हाईकोर्ट के निर्देश पर यह केस प्रारंभ हुआ था एक जनहित याचिका के द्वारा, और इसको लेकर संदेह 1950 से कांग्रेस नेताओं में था. अब दूसरा एक आपको और बहुत रोचक परंतु गंभीर और चिंताजनक उदाहरण, कांग्रेस के बहुत वरिष्ठ नेता जो 4 बार उत्तर प्रदेश के मुख्यमंत्री रहे, श्री चंद्रभानु गुप्त, उनके संस्मरण जो कि 2021 में प्रकाशित किए गए, जिसका शीर्षक था सफर कहीं रुका नहीं झुका नहीं, नमन प्रकाशन लखनऊ के द्वारा. वो लखनऊ के पान दरीबा क्षेत्र में रहते थे. हम लोग तो, मैं तो खैर बचपन में उनको देखने का भी मुझे अवसर मिलने का. अब देखिए, CB Gupta, the 4-time Chief Minister of Uttar Pradesh, writes in his memoir, I am surprised that the National Herald is now considered as a property of Nehru family. If there is some investigation by an inquiry commission into how the funds were collected for National Herald, there will be a big expose. From the very beginning of the policy of National Herald was to promote Nehru and his daughter. For freedom of press meant attacking whosoever criticized the wrong policies of Nehru family. ये श्री चंद्रभानु गुप्त, जो कई बार उत्तर प्रदेश के मुख्यमंत्री रहे, कांग्रेस के वरिष्ठ नेता रहे, स्वतंत्रता संग्राम सेनानी रहे, ये उनका वक्तव्य है, कोट अनकोट हमारा वक्तव्य नहीं है. अब आगे देखिए नेशनल हेराल्ड के बारे में और भी खुलासे वाली बात है. वी ऑल, आगे वो लिखते हैं, आचार्य नरेंद्र देव, शिव प्रकाश, शिव प्रसाद गुप्ता, पुरुषोत्तम दास टंडन, ये सब बहुत बड़े नाम हैं. पुरुषोत्तम दास टंडन जी आजादी के बाद पहले कांग्रेस अध्यक्ष बने थे, जिनसे नेहरू जी ने स्टेप डाउन करवा दिया था कि सत्ता का केंद्रीकरण 2 जगह नहीं होना चाहिए. आज ये लोग कहते हैं ना कि अथॉरिटी वाली बात. अब सुनिए, वी ऑल, आचार्य नरेंद्र देव, श्री प्रकाश, शिव प्रसाद गुप्ता, पुरुषोत्तम दास टंडन एंड माई सेल्फ मीन्स CB Gupta sold shares. 100 shares were bought in the name of Nehru so that he could be named as its director. यानी CB Gupta क्या कह रहे हैं कि आचार्य नरेंद्र देव, श्री प्रकाश जी, शिव प्रसाद गुप्ता, पुरुषोत्तम दास टंडन और चंद्रभानु गुप्त के शेयर्स को बेचने को कहा गया और 100 शेयर से अधिक जवाहरलाल नेहरू जी के नाम पर लिए गए, उनके द्वारा लिए गए, ताकि वो इस कंपनी में डायरेक्टर बन सकें. Some money was taken from Congress and part came from the money bags gifted to Nehru and other leaders. When I started collecting money for that, it was said that I wanted to take control of the paper. Still, I helped the newspaper during the crisis. मुझे लगता है कि अब इस नेशनल हेराल्ड के केस की कहानी में ईडी की कहानी तो बहुत किनारे हो जाती है. अब तो ये कांग्रेस के वरिष्ठतम नेताओं की जुबानी, स्वतंत्रता संग्राम सेनानियों की जुबानी, कांग्रेस का पूरा चरित्र, चेहरा और चिंतन मुझे लगता है बेनकाब हो जाता है इसके बाद. और मैं पुनः रिपीट कर रहा हूं, ये सब के सब प्रतिष्ठित न्यूज़पेपर्स ने पिछले कुछ वर्षों में जब ये सब विषय उठा था, बाकायदा एनालिसिस करके किए हुए हैं. और ये भी इसके बारे में एक देश के एक बड़े लीडिंग इंग्लिश डेली ने इस सारी चीज को डिटेल में दिया हुआ है. पुस्तकों के रेफरेंस तो है ही. तो अब मेरा सवाल है कांग्रेस पार्टी से, अब सवाल नैतिक है. कांग्रेस पार्टी ने जिस प्रकार से स्वतंत्रता संग्राम सेनानियों की विरासत के साथ खिलवाड़ किया है, यह रोग बहुत पुराना है और यह सत्ता के समय से ही चला आ रहा है। फिर कांग्रेस पार्टी कहेगी नेहरू को दोष दे रहे हैं। आज मैं पुनः कहना चाह रहा हूं, नेहरू को हम दोष नहीं दे रहे हैं। सरदार पटेल ने लिखा है, सीबी गुप्ता ने लिखा है, पुरुषोत्तम दास टंडन जी, आचार्य नरेंद्र देव, शिव प्रसाद गुप्ता और श्री प्रकाश जी का रेफरेंस है। कांग्रेस के लोगों को कान खोल के सुनना चाहिए। और अभी कुछ दिन पहले कांग्रेस के वरिष्ठ नेतागण कह रहे थे कि हम लोग मतभेद दिखाने का प्रयास करते हैं। मुझे लगता है जो सीबी गुप्ता जी ने लिखा है कि माउथ पीस ऑफ नेहरू फैमिली एंड इट हैज नथिंग टू बट द प्रोपेगेंडा ऑफ और जो पब्लिसिटी ऑफ नेहरू एंड हिज डॉटर, अब इसके बाद भी उनको नजर नहीं आता। तो मुझे लगता है जब उनको अपनी पार्टी के बारे में जानकारी नहीं है, उनके कार्यकर्ता इसके साथ नहीं खड़े थे, उसके बाद कानूनी प्रक्रिया पे आरोप लगाना पूरी तरीके से गलत है। तो मैं कांग्रेस पार्टी के लिए तथ्यों के आलोक में सिर्फ एक ही लाइन कहना चाहता हूं कि वो पैरवी तो झूठ की करता चला गया, वो पैरवी तो झूठ की करता चला गया, बस उसका चेहरा उतरता चला गया। धन्यवाद।
इससे संबंधित कोई प्रश्न हो आप लोगों के? पूछिए सले से।
जब से पूरा मामला सामने आया नेशनल हेराल्ड का, हमने देखा कि जब पहली बार पूछताछ हुई थी सोनिया गांधी से, तब भी कांग्रेस ने प्रदर्शन किया था, और अब जब चार्जशीट दाखिल हो गई तो प्रदर्शन। अब कांग्रेस के नेता कह रहे हैं कि दरअसल ये एक प्रतिशोध की राजनीति है जो केंद्र के द्वारा की।
इसमें दो बातें हैं। यदि वो प्रतिशोध की राजनीति शब्द का प्रयोग कर रहे हैं, इसका मतलब ये मान रहे हैं कि उन्होंने शासन में रहते हुए कुछ गलत कार्य किए थे हमारी पार्टी के विरुद्ध। पहली बात उनके द्वारा स्पष्ट हो गई। दूसरी बात, प्रतिशोध का प्रश्न इसलिए नहीं उठता है क्योंकि यह विषय 2012 में प्रारंभ हुआ और एक पीआईएल के द्वारा अक्टूबर 2013 में दिल्ली हाई कोर्ट के द्वारा इस केस की जांच की शुरुआत हुई। और जब आज मैंने कांग्रेस के स्वतंत्रता संग्राम के समय के जिन नेताओं को कोट किया है, जरा वो प्रतिशोध का आरोप लगाने वाले शोध करके बताएं कि इसमें उनको क्या नजर आ रहा है। और मैं जो पुनः मैंने कहा था, मैं फिर रिपीट कर देता हूं, जो हमारे ऊपर मोदी जी की सरकार पर आरोप लगाते हैं कि उनके नेताओं को कोर्ट कचहरी के चक्कर काटने पड़े, पिछले 30-35 साल की एक लोकसभा बता दें जब इनके नेताओं ने कोर्ट कचहरी के और जांच एजेंसीज के चक्कर भ्रष्टाचार के आरोप में न काटे हों। और उसमें से एक भी जांच इनकी सरकार ने नहीं की थी, सब कोर्ट के द्वारा हुई थी। मैं पुनः रिपीट कर देना चाहता हूं, नेशनल हेराल्ड केस में जिसमें राहुल जी और सोनिया जी मुचलके पे हैं, वो 2013 में रजिस्टर हुआ, हमारी सरकार नहीं थी। कनिमोझी ए राजा जेल गए 2011 में, हमारी सरकार नहीं थी। सुरेश कालमाड़ी जेल गए 2010 में, हमारी सरकार नहीं थी। मधु कोड़ा जेल गए 2008 में, हमारी सरकार नहीं थी। शिबू सोरेन जेल गए 2004 में, हमारी सरकार नहीं थी। मुलायम सिंह और मायावती पे डिस्प्रपोर्शनेट एसेट के केस हुए 2005 में, हमारी सरकार नहीं थी। करुणानिधि जेल गए 2000 में। लालू प्रसाद यादव जेल गए 1997 में। जयललिता जी जेल गई 1996 में। 1994 में झारखंड मुक्ति मोर्चा रिश्वत कांड हुआ, जो कोर्ट में साबित हो गया कि झारखंड मुक्ति मोर्चा के 3 सांसदों ने कांग्रेस को सपोर्ट किया था। और तो और 1987 में राजीव गांधी पे आरोप लगा, 90 में एफआईआर हुई। 80 के दशक से 2010 के दशक तक क्या गौरवपूर्ण गाथा है भ्रष्टाचार में आकंठ डूबे रहने की। और उसके बाद आप देखिए कि किस धृष्टता और निर्लज्जता के साथ 2014 के बाद पर्ची फाड़ने का प्रयास किया जाता है। Actually, they have lost all their standards of politics and morality. So this has become nothing but their, you can say, their compulsion to give this type of reply. I have already in my previous answer has given a detailed elaboration of that the Congress been involved in so many cases. Prior to that, I just want to remind even the Congress Prime Ministers, first time there was an allegation about the Prime Minister being direct involved was during the time of Rajiv Gandhi ji when BJP was 2 seats party. So I think they first introspect, and the people of country are wise enough, and today is the age of information. Anybody can go and verify the facts, what we are saying and what they are saying. And again, I would like to remind, जो allegation राजीव गांधी पे लगा था बोफोर्स हमने नहीं लगाया था, दैट केम फ्रॉम विद इन द गवर्नमेंट. द फाइनेंस मिनिस्टर ऑफ राजीव गांधी गवर्नमेंट श्री विश्वनाथ प्रताप सिंह हैज पुट अप द एलिगेशन. तो साहब आप अंदर झांकिए, जो दिल खोजूं आपना मुस्सा बुरा न कोय, बुरा जो देखन में चला बुरा न मिलिया कोय.
और कोई किसी का प्रश्न?
एक और मामला है रावत वाड्रा, जिससे पूछताछ चल रही है, आज भी पहुंचे हैं, उस पर कुछ टिप्पणी करना चाहेंगे आप? वहां भी कहा जा रहा है कि ये सब जानने।
देखिए, ये न्यायिक प्रक्रिया चल रही है. मुझे लगता है कि जो विधि सम्मत कार्रवाई हो रही है और जांच एजेंसियां जो भी अपनी रिपोर्ट दे रही हैं, उसके ऊपर राजनीति न करके उसे न्यायिक और विधिक प्रक्रिया के रूप में देखना चाहिए.
ओके सर, थैंक यू.
मुझे लगता है पश्चिम बंगाल में जो दुर्दांत और दुस्साहस उग्रवादी तत्व कर रहे हैं और उसके बाद तृणमूल कांग्रेस की सरकार की ममता जो उनके ऊपर दिख रही है और इंडी गठबंधन ने जो सेकुलर मौन धारण करके रखा हुआ है, यह देश के समाज और लोकतंत्र के लिए यह चुप्पी बहरा करने वाली है. हम बहुत साफ साफ उनसे पूछना चाहते हैं कि अनेक अवसरों पर कलकत्ता उच्च न्यायालय टिप्पणी कर चुका है तृणमूल कांग्रेस के ऊपर, और आज हम सिर्फ एक बात कहना चाहते हैं. जो दृश्य आप मुर्शिदाबाद में देख रहे हैं और जो दृश्य बांग्लादेश में दिखते थे, क्या इसमें कोई बहुत भारी अंतर दिख रहा है? जबकि बांग्लादेश में मोहम्मद यूनुस की सरकार है और पश्चिम बंगाल में ममता बनर्जी जी की सरकार है, मगर हौसले दोनों ही जगह उग्रवादियों के, अतिवादियों के और हिंदू विरोधियों के उतने ही बुलंद हैं, सरहद के इस पार या उस पार. तो मैं ममता जी को बताना चाहता हूं कि आपकी सरकार ने संदेश खाली में नोआ खाली की याद पुनर्जीवित करवाई थी. आज जो मुर्शिदाबाद में हो रहा है, जिस ढंग से वहां हिंदुओं को पलायन करना है, ये 16 अगस्त 1946 के डायरेक्ट एक्शन की याद दिलाता है कि एक कुछ एरियाज में डायरेक्ट एक्शन हो रहा है. और जैसे उस समय बंगाल का चीफ मिनिस्टर सोहरावर्दी बैठकर परोक्ष संरक्षण दे रहा था और कांग्रेस भी उसके साथ थी, आज कमोबेश ममता बनर्जी जी की सरकार वही भूमिका निभाती नजर आ रही है. मैं एक पॉइंट में और भी कह देना चाहता हूं कि ममता जी के प्रति मेरी पूरी सहानुभूति है, क्योंकि उन्होंने इन उग्रवादी तत्वों को इतना सर चढ़ा लिया था कि आज अगर ममता जी यह समझ भी रही हों कि गड़बड़ हो रहा है, तो वो चाह कर भी कुछ नहीं कर सकती हैं. वो पूरी तरीके से विवश हो चुकी हैं. इसलिए यह सरकार अब एक प्रकार से अतिवादी उग्रवादी तत्वों के हाथ बंधक हो चुकी है, ममता जी चाहें या ना चाहें.
सर, तो साफ ही कह चुकी है कि वक्फ कानून को वहां पर इंप्लीमेंट नहीं करने देंगी. क्या आपको लगता है कि ऐसा हो सकता है कि एक राज्य में केंद्र सरकार केंद्र के द्वारा पारित किया गया वो कानून इंप्लीमेंट ना हो पाए?
देखिए, मैंने पहले भी कहा था कि 73rd एंड 74th कॉन्स्टिट्यूशन अमेंडमेंट के बाद ऑल 3 टियर्स ऑफ गवर्नमेंट की पावर्स डिफाइंड है, सेंट्रल गवर्नमेंट, स्टेट गवर्नमेंट एंड डिस्ट्रिक्ट गवर्नमेंट. कोई डिस्ट्रिक्ट गवर्नमेंट अपनी स्टेट असेंबली से पारित कानून के को मानने से इनकार नहीं कर सकती. उसी प्रकार कोई भी राज्य सरकार केंद्र के द्वारा पारित कानून को मानने से इनकार नहीं कर सकती. अगर कोई यह कहता है, इसका मतलब वो संविधान को जेब में रखता है, और मोदी जी की सरकार संविधान को दिल में रखती है, जेब में नहीं. और ये जेब में रखने वाले लोग, जिन्होंने उस प्रॉपर्टी को भी अपनी बपौती समझ रखा था, उनको मैं बता देना चाहता हूं कि वो दिन चले गए जब वो ये आके कहते थे, जैसे वो बादशाही जमाना होता है, जिस इलाके पे उंगली कर दी बस वो आपका हो गया. नाजिशे लोहे करम साहिबे आलम हुक्मरान वक्त वली हैद सल्तनत, उस मानसिकता से बाहर निकलिए और बाबा साहब के संविधान के अनुसार अगर आप उसको मानने से इनकार करते हैं इंडी गठबंधन और कांग्रेस और तृणमूल कांग्रेस, इसका मतलब बाबा साहब के संविधान का सीधा सीधा अपमान कर रहे हैं। और मैं याद दिलाना चाहता हूं, कोर्ट में भी ये लोग इसी प्रकार की दलील दे रहे हैं। क्या कह रहे हैं कि ये मुस्लिम्स का मामला है। मैं आपको एक कोट बोल रहा हूं, सिंस द मैटर इज रिलेटेड टू द मुस्लिम्स एंड मुसलमान, सो देयर वेयर इज द क्वेश्चन ऑफ पब्लिक पॉलिसी अराइजेज। आपको यही लगे ना ये कोई विपक्ष का नेता बोल रहा है या अभी हाल में पार्लियामेंट में, लोकसभा और राज्यसभा में बोला होगा। नहीं साहब, ये अप्रैल 1913 में मोहम्मद अली जिन्ना ने इंपीरियल लेजिस्लेटिव काउंसिल में वक्फ के समर्थन में बोला था।
अगर आप बनना चाहते हैं एंकर या फिर आप में है जुनून एक तेज तर्रार न्यूज रिपोर्टर बनने का, तो आप ज्वाइन करें ITV और इंडिया NewsX का मीडिया स्कूल। ITV नेक्स्ट मीडिया इंटरनेशनल स्कूल का कोर्स आपको मौका देता है देश के दिग्गज एंकर्स के साथ काम करने का। ITV नेक्स्ट मीडिया इंटरनेशनल स्कूल में आप बेहद नजदीकी से देख पाएंगे किस तरह से ITV नेटवर्क के दिग्गज पत्रकारों की टीम दिन रात खबरों पर काम करती है। इस कोर्स के दौरान आप सीखेंगे एंकरिंग की एक एक बारीकी उन एंकर्स के साथ जो देश को रखते हैं हर खबर से बाखबर। ITV नेक्स्ट मीडिया इंटरनेशनल स्कूल का ये कोर्स आपके एंकरिंग स्किल्स को करेगा इतना सशक्त मजबूत, जिससे आप बनेंगे पत्रकारिता की दुनिया का वो चमकता चेहरा जो दुनिया देखेगी और पसंद करेगी। अगर आप बनना चाहते हैं एंकर या फिर आप में है जुनून एक तेज तर्रार न्यूज रिपोर्टर बनने का, तो आप ज्वाइन करें ITV और इंडिया NewsX का मीडिया स्कूल। ITV नेक्स्ट मीडिया इंटरनेशनल स्कूल का कोर्स आपको मौका देता है देश के दिग्गज एंकर्स के साथ काम करने का। ITV नेक्स्ट मीडिया इंटरनेशनल स्कूल में आप बेहद नजदीकी से देख पाएंगे किस तरह से ITV नेटवर्क के दिग्गज पत्रकारों की टीम दिन रात खबरों पर काम करती है। इस कोर्स के दौरान आप सीखेंगे एंकरिंग की एक एक बारीकी उन एंकर्स के साथ जो देश को रखते हैं हर खबर से बाखबर। ITV नेक्स्ट मीडिया इंटरनेशनल स्कूल का ये कोर्स आपके एंकरिंग स्किल्स को करेगा इतना सशक्त मजबूत, जिससे आप बनेंगे पत्रकारिता की दुनिया का वो चमकता चेहरा जो दुनिया देखेगी और पसंद करेगी।
There you have the first glimpse of the Prime Minister. It's a big moment. People of Anuradhapura have been awaiting.
India can help us technically as well as economically to build up the country.
We take the next step in ensuring a closer relationship between the two countries.
India was the biggest assistance out of the countries.
There are so many similarities that make us kind of a home very quickly.
I've been born and brought up here in Sri Lanka, but my parents are of Indian origin.
The Independence Day celebrations take place in this historic place that was built in 1948.
Sri Lanka has had great ties with India on across all spheres. When you buy an Indian map, you get a Sri Lankan map free of charge. That is a common saying. That means we are inseparable.
NewsX World reports to you from Ground Zero. The disaster hit Bangkok. Another mortal remain of a person was found just a while back.
Seeing these visuals coming in from Thailand, firstly, Bangkok.
No electricity, no line, no telephone, no nothing.
There you have the first glimpse of the Prime Minister. It's a big moment. People of Anuradhapura have been awaiting.
India can help us technically as well as economically to build up the country.
We take
Hello and welcome. You're watching NewsX and I'm Megha Sharma. This is the big breaking development. The Supreme Court hearing in the Waqf Amendment Act challenge that has been made by a number of petitioners. The batch of pleas that are challenging the constitutional validity of the Waqf Amendment Act 2025. It was passed by the Parliament earlier this month. The Supreme Court has asked the centre how Waqf by users would be registered as there may be lack of documents. The Chief Justice of India has asked Solicitor General Tushar Mehta where public trust has been declared as Waqf about 200 years ago, and it has spoken about the validity of the Waqf board. Tushar Mehta has further said that all right, these are developments coming in. Sambhav on the telecast with me. Sambhav, what's the latest?
Yes. Well, the latest in this is the Chief Justice of India has issued a notice and asked to file the replies. The hearing happened for around 2 hours. It's a very crucial hearing on Waqf Amendment Act challenge in the Supreme Court, and the Solicitor General here, Tushar Mehta, the law officer of the government, said if somebody has created a trust, it will remain a trust. That's so, as he has made it very clear that merely because it is for a Muslim purpose, it will not be a Waqf, and there is he also quoted some other judgments. Now, the very crucial and important thing with the Chief Justice of India, Sanjeev Khanna, has said as per Chief Justice of India, there are two options. First option is for the Supreme Court to and the other option is to send it to a common High Court or take pending petitions from the High Court to the Supreme Court and decide here. So either the Supreme Court may give power to one High Court to hear all the pending petitions, or take all the petitions from different High Courts of the country challenging Waqf to the Supreme Court and hear the validity of the particular act in the Supreme Court. This is what the CJI has said.
to which the Solicitor General said that please hear it, we will file a reply in 2 weeks. So the central government will file a reply on the notice issued by the Supreme Court. Supreme Court has issued the notice. Center will file a reply in 2 weeks. This is what the latest in this, and now it is to be seen what happens next. For the time being, the breaking news is
okay. All right, stay on with me, Sambhav. Thanks for giving us all those updates. I'll keep coming back to you to get a update on all that's happening inside the court. Meanwhile, it's been a day after India's retail inflation hit a 67-month low. Agencies like CRISIL and Moody's have maintained that India's GDP growth forecast to be at 6.5% through the next fiscal year. India also became the first ever country to recover all its market losses due to Trump tariffs. India's markets have rallied for 3 consecutive days, with Sensex crossing 77,000 mark. India's exports have also surged 5.5% in the recent year and are estimated at $820 billion. Meanwhile, Trump has hiked tariffs on China to a total of 245% is what he has warned. He has said that the ball is now in China's court to make a deal with America. China has reacted and warned Trump against exerting pressure amidst concerns of India facing the impact of Trump's tariffs. What is the state of the economy and what can we expect next? Let's start our conversation. Joining me on the telecast is Sharath Kohli. Thank you. And the first question arises is that a record low when it comes to the inflation in the country at 3.34% for the month of March. What does it indicate?
Good evening, Megha. Good evening to my fellow economists and the NewsX viewers. Yes, I think 67 months low, this particular inflation, 3.34%. And a huge relief which has come on the food inflation front, because food inflation was the one which was really causing a headache to RBI. And it was a matter of concern for the whole country as such. Even the government was concerned. So was the Reserve Bank of India. And I think all out steps were being taken to try and see that food inflation comes under control. There was a lot of hoarding. There was black marketing. There were supply chain disruptions, which I'm glad they have been set right. And other parameters, when we talk of the economy, we talk of exports crossing $820 billion. Out of this, $440 billion plus is merchandise, which is very good. GST collections at almost 2 lakhs a month. Direct tax collections growing between 16 to 20% per annum. The purchase managers index not in a bad shape at all. Take any parameter for that matter. But there are, mega two opposite winds blowing in the country at this time. Whereas the domestic scenario looks very good. But when you look at the international scenario, there is complete uncertainty. Thanks to the Donald Tariff Trump, the Trump administration having declared trade war. And 5 business associations, Megha, in America have filed a writ in the court that after all, trade deficit which America has with the rest of the countries is not sinful. It is not possible to have a 0-0 with all the countries. It is normal for countries to have, trade surpluses and trade deficits. His approval rating has gone down. On economic front, President Trump's approval rating has gone down to 30% or 33%, sharply down from the time he was elected just a few months ago. His ratings on immigration may have still been over 50%, but his ratings on economic front, Megha, has gone down. As for our country, we have been negotiating. There's a BTA in the process, which is most likely to be converted to an FTA. So we are not at all in a bad position vis-a-vis tariff. But then we cannot forget the fact, Megha, that if 2 of the largest economies are thickly involved in a trade war, we cannot remain immune completely like the rest of the world. $50 trillion is the GDP when added together of America and China. So we cannot remain immune if they get into this severe 245% tariffs, which today were spoken of, basically means don't trade with us. Imagine if America and China stop trading with each other. What happens? There'll be dumping carried out by China. President Xi Jinping is already on a mission. He's going to Vietnam, Indonesia, Malaysia. He's trying to bring them together to see where he's going to dump his goods now. And America, what are Americans going to do? They were so used to these Chinese goods. How are they going to manage? Either there's going to be inflation, or there's going to be shortage of goods, or America is going to spell itself into recession. Can President Trump set up factories? The reason why he exempted mobile phones and laptops and computers is because he got a ground report that, for God's sake, these factories cannot be set up overnight. As if the rest of the factories can be set up overnight. Even they are not going to be set up. I'm sure the reality of these announcements are gradually sinking into, and I was the first one on your channel. I normally don't boast, I don't flaunt, but I was the first one on your channel when on 2nd April he made these announcements. I said he will have to soften his stand, and you wait and see, he will have to soften the stand further. But if China, America, they get into a trade war, I have a feeling, and I would hesitate to say that, Megha, that this can also lead to a geopolitical conflict, because it is going to cause extreme economic distress between the two countries. Where this is heading towards, both the countries will have to sit down together. That's the only way this can be resolved. There is no other way, Megha.
Okay, all right. Ajay Dua, let's take a look at the India scenario. About the 67% inflation all-time low that India has witnessed. We see that there has been a rate cut that has been announced by the RBI twice in the first half of the year itself, talking about how Indian stocks have recovered after the Trump tariffs that had been imposed. So India has been the only economy that has recovered as fast as it has. How are we able to revive and rebound amidst economic uncertainty that has hit hard countries across the globe? China particularly, Malaysia, Vietnam, all of them have been heavily impacted.
Thank you, Megha. We're talking very briefly about inflation. Yes, as has been pointed out already, it's the food prices which have come down, and food in our CPI does form a fairly large chunk, both particularly at the lower end of the pyramid, and that means about 40% of the people in India do have food as a major constituent of their expenditure, and that's good. Let's hope that the Kharif crop, which is almost ready for harvesting, Baisakhi is over a couple of days ago, that it does turn out to be good, and unlike in the past, the crop will be a little more diversified, more pulses. We would have more of horticulture products, we will have more of vegetables as well. As of now, things look on that. I'm keeping my fingers crossed. You never know when the weather can change. But prediction of IMD is that it could be early monsoon, which again means good for agriculture and good for food price. I am very sanguine about that. Second issue is, you talked about Indian stock market bouncing back. Yes, it has done well. Very few countries in the world have experienced that. But for that, I think we have to thank President Trump, whether we like it or not. The counter tariffs or the reciprocal tariffs imposed on India are relatively less than on other countries with whom we trade, be it China, as we all talked about, 200% duty being talked about, Vietnam, a satellite, so to say, economy, not independent country altogether, and I like it, I was recently there, but the fact is that there is a fair amount of Chinese investment and there is a fair amount of trade between Vietnam and China. But relative rates applied to them vis-a-vis India kind of bode well for India. That is why the stock market reacted positively very quickly, though there is a respite of 90 days. Thinking that it does show what might be the future, whether it is by way of BTA getting signed by September or October when President Trump is likely to be in India for the Quad Summit meeting, or even a little earlier. During the 90 days itself, some signatures may be done on bilateral. That's again a positive one for us. The third one, which you've talked about, is I think equally important for us, that the rate cuts. Yes, the previous governor wasn't kind of listening to the government's messages to him. Shashikanta Das, a friend of mine who's worked earlier, we worked together, etc. But the present one is very clearly indicated. Sri Malhotra has said 25% cut within a few days of his coming, and within 2 months, in the next review, another 25. So it is softening of this will help inflation. This should help more investment to take place, particularly by the private sector and the small. Having said all these positive things, I would still keep my fingers crossed.
Okay.
The flip-flops of President Trump. See, yesterday, 2 days ago, he exempted phones, chips, as well as certain other electronic items. Now he's talking of imposing high duties, including he's ordered an internal inquiry saying how was he misled by his own people in the United States who helped him take that decision. So there's an investigation taking place on that.
Okay.
Second, I'll just end by saying, I fear that there could be also a reversal of roles. Today, if we do not play ball, if we were to act, today we have acted discreetly, but if we were to join China in getting greater trade, or someone else whom President Trump doesn't like, you might have penalties visiting you as well. And that means all that we have talked about, favorable trade, favorable inflation, and favorable foreign trade could reduce its impact, if not come to a naught.
Okay. All right. The chances of that are nil, as we can see the scenario between India and United States of America. There have been trade representative level talks that have taken place. There is likelihood of the Vice President J.D. Vance, who will be arriving in India as soon as next week. So there are going to be an anticipation of big announcements with regards to a trade deal, a bilateral trade agreement that India and US have been pushing for the past few weeks and months, ever since Prime Minister Narendra Modi also visited and met President Donald Trump. I'm going to come to Mitali over here and talking about how it is a silver lining for India amidst the trade war that is taking place between US and China, because 24 hours ago there has been a revelation that has been made that a record number of iPhones manufactured in India were imported by Apple right before the Trump tariffs were brought to force. There is also a Wall Street Journal report that says that the Trump trade officials are going to be negotiating with the 70 countries to disallow Chinese goods to be shipped from their territories into America. Do you think supply chains are going to look favorable in India's position, in India's favor here on, when it comes to building more trade ties, bigger, stronger trade ties between India and US, and also the fact that China has been visiting and meeting their Vietnamese leader, and now he's in Malaysia, and tomorrow he's going to be in Cambodia signing those agreements and deals. Which way are these Southeast Asian countries going to sway is going to be paramount in how the American economy is going to react.
Absolutely, absolutely. So thanks a lot for bringing me into the conversation. I think there are a couple of very pointed, questions that you've raised, and I'd like to go through them. The first thing is that, the North Star that Prime Minister Modi has set for us. And yesterday you would have noticed that the terms of reference have been signed between the Indian authorities and the US authorities on actually negotiating a trade agreement. And India is amongst the first countries to go ahead and sign that terms of reference in order to negotiate the trade agreement. And that puts us far ahead of other countries in terms of, aligning our supply chains and supply lines clearly with the US side, the way Vietnam has done with the Chinese side, as you were describing. I do expect that, India will definitely, in terms of doing business, if we have to really choose, then obviously we have to choose the US side, because the Indian economy is already well integrated with the US economy. 75% of our IT exports actually go to the US or to US denominated companies. And that's one of our major sectors when it comes to employment, and also one of the major strengths for India when we are moving forward, when we are moving and creating more and more businesses in the AI era. You would have also noticed that today President Trump has announced a 245% tariff on China. On top of that, Nvidia, which is one of the biggest chip makers in the world, has actually been stopped from exporting chips to China in a soft way. And this means that President Trump is essentially saying that the AI revolution and the AI work that is happening in the US should stay within the US, and also should stay within companies, and technologies should be shared only with those countries which are negotiating this trade agreement. So I really hope that India will get a piece of that pie and will be able to be a partner with the US when it comes to artificial intelligence and technology, because that is very critical for the continued growth of our IT industry. The third aspect, which is very critical, is, you mentioned about Southeast Asian countries, which way are they going to go? And definitely we are already seeing some of the Southeast Asian countries will align more closely with China. Some of them, like Singapore, for example, is a very interesting case, because Singapore is very clearly aligned with the US, particularly in their financial services trade, but, because they don't have much goods trade. So the countries where you see a lot more goods trade is taking place in Southeast Asia, I do expect a closer alignment with China. However, the ones where services are dominating, especially in services, I expect a closer alignment to occur with the US. But for India, really, the real question is, how do we protect our agriculture industry? Because that is one area where the US might ask us to open up. And that's really one area where, through continued innovation and through more and more technology and investment, we have to open it up maybe a little bit, but at the same time, ensure that our farmers are protected. And finally, I would say that, when we're talking about the electronics industry, when we're talking about the semiconductor industry, these two industries offer a very, very big opportunity to India. Like you mentioned about mobile phones, if we are able to navigate and we are able to get this trade agreement in place, then, the continued export of mobile phones or other electronics can happen from India to the US under the terms of reference and under the framework agreements that we would sign. And of course, the US realizes, like Sharadji rightly said, that you can't actually bring factories overnight into the US for manufacturing. But when you have a strong manufacturing base in a country like India, and the China plus one strategy was always afoot, what has happened now is that China plus one strategy is now on steroids, right? Because we're sort of saying we don't want to deal with China anymore. That's a message coming from the US.
Yeah. Also, feelers being sent out, Akash Jindal, from China to India. Yesterday, the Chinese ambassador to India came out and said that I think from 85,000 of the visas that have been processed for Indian nationals to come and live and work and travel to China, and the term that has been used is very affirmative, going about saying we are inviting our Indian friends to come and visit China and work in China and build business in China through those visas that have been processed. Chinese are also wanting to increase their investments within the country. They want to do more trade with India. Which way is India going to go?
Well, Megha, it's very nice that Chinese are using the words, we want Indian friends. I'm happy that they are still not using the words Indian brothers, because they have been using that Hindi Chini Bhai Bhai and doing with us what they should have not done. But I think it's good for India to bargain things with US. So it gives the India leeway to bargain things, because the way China wants to come closer to India, the way they want to have a, I mean, love affair with us, short term, long term, I don't know what they want. But yes, with all the offers which China is giving us, the way they are talking about visas, the way they are talking about Indo-China friendship, business increasing, I think that definitely gives India a strong point, a strong basis for demonstrating US that yes, we want to do business with us, but there are options. China is coming close to us. So that gives us a strength of bargaining things with Donald Trump and his administration. So I think if China is sending us offers, it's nice. We should just keep on listening to the offers. But I think US definitely is going to be a better trading partner for India. Though let me inform your viewers that for many months it was not US but China who has been our biggest trading partner. People in India have a perception that it's US who has always been India's biggest trading partner. For many months, China has been our biggest trading partner. So I think let them keep on sending offers. Let us keep on receiving and listening to their offers. But beyond listening, I don't think we should do much with them. We shouldn't forget what they tried to do 2 to 3 years ago on our borders. Of course, our bravehearts, they replied them very well. We should never forget that the way they have been helping Pakistan in Pakistan has been doing terrorism in India, and China has been openly supporting them in all their activities. So we shouldn't forget any of these things, and we shouldn't forget China. Right from 1961, 62, we shouldn't forget what China is. So I think we'll be able to bargain nice deal, because now if you try to see what Donald Trump has been saying, he has been tough on those people who have tried to retaliate, but those people who have tried to negotiate, he has been soft on them, and particularly the chemistry which Narendra Modi Sahab, our Prime Minister, shares with Donald Trump is such that I am sure my organization, Akashindal.in, is sure that we'll be able to negotiate a deal with them. Even the day when he had reciprocal tariffs for India, he said, Prime Minister Modi is a great friend of mine. So I think it's good for India to negotiate things with US. As far as Indian economy is concerned, I think we are performing excellently well. I'll give you some numbers. Now, after US levied tariffs on China, Canada, and Mexico, in the month which was after that, March 2025, our GST collection has been 1.96 lakh crore. February 2025, our